Hello, everybody. It's Nicole Gaither with Creativa IP Law. I'm here to tell you about the Legend of Coco. Not this Coco, but this Coco. So, this story came out back in January, and I think it was probably not really shared a lot, or a lot of people didn't understand what was going on. So, there's a lot to unpack here, and I'm going to try to explain it. But Coco, this Coco, is an image that you probably have seen on a lot of places. Like you've probably seen her on totes, and avatars that people have been using, profile pictures, all of that. Apparently AKs are very in love with it. Shout out to the AKs. But I saw this article back in January and something triggered it back to me when I talked to someone that I met yesterday at Entrepreneur Week that's being held here in New Orleans. And she was stating that she's actually afraid to use her logo because she doesn't want anybody to copy it. So we've already had our little chat about that. Charlize Foster, and forgive me if I'm mispronouncing that, designed this logo, or this, she did a graphic design for a beauty salon owner. And the beauty salon owner actually called it Coco, but she designed it while she was still in school. And it sounds like there was not any kind of agreement about who would own what for the logo or the design. But apparently the beauty shop owner decided to move forward with getting a federal trademark for it because she started using the design on merchandise. So like it was being featured on t-shirts. Of course, she's featured on things related to her salon, all that stuff. So she receives a federal trademark registration for the logo featuring this design. Fast forward when Charlize Foster is now ready to graduate from school and start looking for a job. And she sees during a Google search that her design that she did for the beauty shop owner is now being featured and used by people as their profile picture. She did a reverse Google search and is now seen where it is like almost everywhere. Like it made it all the way to Nigeria. So she has spent time, she's spending time now at this point trying to track down who's using it, how they got it, trying to get people to remove it because she's, basically it's her work. Then they run into a problem. She actually contacts the beauty salon owner who trademarked it because they now find out that someone is using Coco on a tote bag and selling it for $75. And I'm not going to reveal the name of the person who's selling it because that's a whole nother issue in itself. And, that's not what this story, it is what the story is about, but I'm not trying to target her because I'm not involved in this matter. Charlize and the beauty salon owner both contacted the tote bag owner, and I'm sorry, the Employee of the Month has decided to make a featured appearance, but forgive me. So Charlize and the beauty salon owner contact the tote bag owner, the tote bag store owner, about, if you are going to use this design, like first of all, the beauty salon owner who owns the trademark told her she could license it to her. Like she was willing to work with her. Of course, she's being told that she's greedy because she wants to get money off of it. She owns the trademark. She has the right to ask you for money. You're lucky she's asking you for money and not trying to sue you. Poor Charlize is just telling her, just stop using it because it's my design. I will design something for you if you want me to do it, and it'll be like your particular design. Lady said, I'll get back to you, and never did. So for a while, the tote bag store owner, actually stopped selling the tote bags for a while. But then all of a sudden, a few months later, it pops up again on her, storefront, and she's selling them again. So, at this point, the trademark owner, the beauty salon owner who owns the trademark, and poor Charlize, they were trying to figure out, what's the best course of action here? So, Charlize basically suggested, let's just sue her. However, the trademark owner was like, it's expensive unless you want to go in with me. I'm almost to the point where I'm just giving up. Which is unfortunate because in this situation, that trademark owner actually has the right to get her, funding or money that she has lost as a result of this person who's selling these tote bags and any other thing because they're infringing on her trademark. And then let's kind of back up to Charlize here, the person who originally designed the logo, or Coco in this case. First of all, it sounds like based on the story that she gave that there was no agreement between her and the beauty salon owner for the design. So unfortunately for her, she still owns the copyright. However, it sounds like she didn't register it, so she didn't take that next step. And there's probably going to be some confusion, and it really shouldn't be, because you're required to have a written agreement if you are going to have someone do a design for you and you plan on owning the design. So I'm going to kind of explain that. So let's say you have a company or store and you want to have a logo. So you go to a graphic designer or an artist that you know, and you ask them to do a design for you. That person does the design for you. It's considered a work for hire because they did it because you commissioned them to do it. You need to have a written agreement if you're going to actually own the copyright in that work and use it as a part of your trademark. So that needs to be written, and then you need to file and register that trademark and file and register the copyright in that design so you can have protection both ways. Now, if the designer decides that they want to maintain and retain the copyright, then that, there's no written agreement required for that. However, you probably should have an agreement just so everybody knows what's going on with it. Because if you're using a logo and then somebody else is now, like the designer's like using it in their portfolio and then hopefully not selling it to other people, but you need to make sure that that is going to be your logo and it's not going to be used on other things that are going to be basically infringing on your logo and causing confusion in the marketplace. So, like I said, there's a lot to unpack here. I mean, ultimately, there sounds like there should have been a copyright that was registered. The trademark owner definitely should have, policed her trademark, because now it's out there and I don't even know if she still has the rights to claim it as a trademark if someone makes the argument that she wasn't policing it the way she should have. Work for hire agreements are definitely required if you're going to have someone design artwork for a logo that you're going to use so that you can own the copyright. There are no questions about it. You don't want that person actually using that logo or that design later and selling it to other people. So have a work for hire agreement. And these are things that attorneys can assist you with. Like I said, you can always file your own trademark application. You can always file your own copyright registration application. However, the nuances about, eventually finding out that somebody is infringing on your work and, trying to handle all the, requesting people to take stuff down and sending out emails, there's other things you can be doing with your time. That's what lawyers are for. So hopefully, you all have kind of learned something important from this, that definitely protecting your intellectual property rights is necessary. I hate doing the fear factor thing, but I feel like it's important because some people just don't get it. If you have any questions, feel free to drop them in the comment section or click the link. You can ask me a message. You can message me and ask me a question, or you can join my Facebook group. It's the Speakeasy with a trademark and copyright lawyer, or it might be Speakeasy with a copyright and trademark attorney. Forgive me, but I'm going to post it there so you all can get it right. Just so if you have a free space, you can ask these questions. So that is your things you should probably need to know, the IP fear factor thing on trademarks and copyrights. See you all later.